and Merry Christmas from me to you. Christmas is a special time of year for me and my family, and whatever holiday you're celebrating with your family, I wish for you to have at least one special season of joyful celebration with friends and family. Now, in your business, do you send Christmas cards or holiday cards? Or maybe you just send Thanksgiving cards to avoid the issue altogether. It could be that you're celebrating Mawlid al-Nabi, the birth of the Prophet Muhammad, in January, although I realize this is controversial in Islam. Regardless, Merry Christmas is a hot button topic. But this whole Merry Christmas issue makes me want to remind you that saying Merry Christmas is different. Religion is a different protected characteristic for your employees. If you want to wish Merry Christmas to your customers, that's your decision. As long as you're not the government making the decision to say Merry Christmas, then you're pretty much free to talk about whatever religious holiday you want. Now, governments have to be more inclusive, and that brings up a whole nother line of constitutional law issues that's way too complex for this video. But I wanted to remind you as the business owners that whether to say Merry Christmas or Happy Holidays or Season's Greetings brings up that difference for religion among your employees. It's different from most other protected characteristics because you have to accommodate the religious practice. And I don't want you to be surprised by a discrimination charge that you never saw coming. Religion is different because employers of a certain size have to accommodate their employees' religious practices. Religion is like disability, and to some extent, pregnancy. You have to treat race and gender and national origin the same or consistently. And if you do that, you're fine. But if you treat your employees uniformly based on religion or without considering their religion, you could face a losing lawsuit. So let's use this Merry Christmas debate as an example. Let's assume that you run a retail store and you want your employees to wish your customers Merry Christmas. An employee tells you she doesn't want to say Merry Christmas because she's an atheist. Now, you may decide this is a quick fix, I'll just give her something else to say, and that's fine. But you're probably also left with a lot of questions in your mind. Is being an atheist a religious belief under the law? Do I have to accommodate atheism? What if it's something I've never even heard of? Does it have to be part of an organized religion? This issue, this Merry Christmas issue, wasn't a big deal to me, but what about the next religious belief that comes up? And how much do I have to change my business in order to accommodate the beliefs of my employees? What if I operated a Christian bookstore? Do I have to give every employee Sunday morning off? What if I know my employee is doing something totally opposite of what they say they believe when they're off the clock? Basically, you don't want to invite a lawsuit by being totally unreasonable, but you are in business, and you cannot run a pizza parlor if you're giving all of your employees Friday and Saturday off. So, the questions that I raised earlier, the ones that business owners want to consider, actually are relevant for this discussion. Here are the questions that you should think about, and that a court is going to think about, and the EEOC is going to think about if you are faced with a religious accommodation issue in your workforce. Is the employee's religious belief a sincerely held belief? Is it something that the employee, in their heart and mind, it makes up part of their religious thought, even if their religious thought is totally not religious at all by your standards or my standards? What is the cost of accommodating this religious practice? And then what is the purpose of your business? And how much does it actually hurt your business if you change that practice? If you're a Christian church, of course, you can require your employees to say Merry Christmas. But what about the janitor at a Christian school? In order to not accommodate the religious belief or practice, you are going to have to prove that the accommodation would have been an undue hardship. Now that could be a monetary hardship or cost, or it could just be the disruption in your workforce. Another question to consider is whether the employee gave you notice that they weren't complying with your work rule because of their religious belief. Now, Abercrombie Fitch is currently defending itself in the U.S. Supreme Court, arguing that an applicant, a female applicant, wearing a headscarf, who wasn't hired, admittedly, because she was wearing the headscarf, that she had not given that boss sufficient notice that she was wearing the headscarf for religious reasons. Now, that seems a little bit unbelievable to me, but what's important for the business owners out there is to hear that Abercrombie Fitch, by not changing their dress code, has gone all the way to the U.S. Supreme Court to defend their actions. Now, most of my clients don't want to be that test case. Most of my clients don't want to defend their employment decisions all the way to the U.S. Supreme Court. And that brings me to the final lesson of today's video. HR decisions are an art and not a science. There is no one-size-fits-all answer for every business and every situation. If you are the Greens and you own Hobby Lobby, or if you are the Cathys and own Chick-fil-A, maybe you've decided that certain management decisions are so important to you that you want to zealously defend those actions as far as you can under our Constitution, all the way to the U.S. Supreme Court. But that's not the norm. At least it's not the norm in my experience. Usually these decisions involve balancing what the employer wants to do, what the employer hopes they can do, and what is required by the law. What this really means is that you're taking the real life risk, the real life cost of changing your practice or not taking a particular action in any given situation. Now, most of the decisions have risk regardless of which way you go. Either you're taking a legal risk by going ahead and terminating the employee or not changing your practice, or you're taking the risk of what is it going to do to your public image if you do accommodate and you do change your dress code and your policy. That's why it's so important to walk through these decisions when they arise with someone knowledgeable about all of these questions that are going to come up. The questions I gave you earlier regarding whether the belief is sincerely held, the actual cost of accommodating it, are the questions that a court is going to ask. And more importantly, that a plaintiff's attorney is going to ask your employee before he or she takes their case. With these questions fresh in mind, I hope it will help you spot those times that you want to slow down, that you want to consult with an attorney or another expert before you take action against an employee. Now, remember, I'm not your attorney, and this isn't legal advice. I haven't learned your situation, your business, your practice. I've only highlighted some of the issues that you face as a business leader based on my training as an attorney. But I hope that it gave you the tools you need to know when to slow down and think harder about a particular situation and when to seek help. So please click that like button, leave me a comment below. I would love to know what holiday you are celebrating this time of year. And also, what do you worry about as a business leader? Subscribe to my YouTube channel and email me at questions@melissamalcolm.com. Malcolm only has one L. Until next time, remember that getting the employees you want means taking small steps over time. It doesn't happen all at once. Thank you, and Merry Christmas.